Let's say you have a critical piece of evidence for a criminal trial, but the only person who can verify it has completely disappeared. How do you get that proof into court? Well, today, we're going to look at a powerful and kind of obscure legal key that does exactly that. So let's set the stage. We've got a piece of evidence that could crack a case wide open. But right now, it's locked away behind a big legal wall. It's basically untouchable. Here's our scenario. Detectives find a getaway car. The problem? They have zero direct evidence linking it to their suspect. The entire case is hanging by a thread, and that thread is a single credit card receipt found in the car. It proves the car was at a remote gas station at a very specific time just before the crime went down. But of course, there's a huge problem. The gas station attendant who handled the sale vanished, gone. Without them to testify, how on earth can prosecutors get that crucial receipt into evidence? It's a legal puzzle that could literally make or break the entire case. So how do we get to that evidence? Well, luckily for us, the law has a special key for situations just like this. Okay, first we have to understand the law. It's called the hearsay rule. And put simply, it just means you can't use something someone said outside of court as evidence because you can't cross-examine them on it. That receipt, from a legal standpoint, it's basically the missing attendant making a statement outside of court. So our crucial evidence is locked up tight. And this is our key. It's called the business records exception. It's a rule that carves out a special little pathway for reliable documents that were made in the everyday running of a business. It's a brilliant example of how the law creates these practical workarounds for real-world problems. But you can't just use this key willy-nilly. Nope, you have to pass a very specific test first. So the court's first big check is this. The person who created the record, our missing attendant, has to be unavailable. Now, this can mean they've passed away or too ill, or maybe they're out of the state and it's just not practical to get them to court, or they simply can't be found. But there's a fourth reason, and this one's fascinating. What if so much time has passed that they couldn't possibly be expected to remember one single transaction from years ago? If you can prove any one of these four things, you've passed the first check. All right, on to the next hurdle. You have to prove the record came from a business, and you might be surprised at how narrow the legal definition can be. You see, the law is very specific. The record has to come from a trade or business. Now, a gas station, that seems pretty obvious, right? But what about, say, a government agency or a public hospital? Suddenly, the answer isn't so simple. And here's why. The courts have basically said that the word business in this context has a commercial connotation. It usually means an activity that involves supplying goods or services, even if it's not actually for profit. It's not just about making money, it's about the nature of the operation. And this is where it gets really interesting to see how this plays out in the real world. For example, the Bank of England, that's been held to be a business. A public hospital, when it's viewed as a utility, can also count. But what about a government customs agency or transport branch? Courts have often said no, arguing those are more like administrative functions, not businesses in that commercial sense. And that little distinction is absolutely vital. Okay, now for the modern twist. These rules were mostly written with paper records in mind. But today, almost everything is digital. And well, that changes everything. The key question the court asks is this. Is the computer acting like a filing cabinet or is it acting like a calculator? Think of it this way. If a computer is just storing and spitting out information that a human put in, like a bank clerk typing in a deposit, it's a filing cabinet. That bank statement is probably getting in. But what if the computer is creating new information? Imagine a lab computer analyzing a substance to figure out its chemical makeup. No human being had personal knowledge of that final analysis until the computer did the math. In that case, the court has said the printout might not be admissible under this rule because it's not a record of what a person knew. It's a product of the machine itself. So after all of that, why is the law so complicated here? What's the big picture? It all comes down to a really delicate balancing act. On one hand, this exception exists to make sure that good, reliable evidence isn't just tossed out because a witness is gone. But on the other hand, all those rules we just talked about, the 4 conditions, the definition of a business, the computer test, they're all there to protect people from unfair or just plain unreliable information. It's a filter designed to let the good stuff in and keep the bad stuff out. And that leaves us with a really fascinating question for the future. You know, in a world where computers don't just store our data, but actually create it, from AI analysis to algorithmic decisions, our old rules of evidence are being pushed to their absolute limits. The core challenge is still the same. How do we adopt our laws to decide what digital proof we can actually trust?